Welcome to Proposal Bites, a series of short discussions on the key issues facing legal services providers when proposing for new business. My name is Sylvia Hodges-Silverstein. I'm the Executive Director of the Buying Legal Council. I'm speaking with John de Forte, author of Winning Proposals, the Essential Guide for Law Firms. Hello, John. One of the great cliches about proposals is that there are no prizes for coming in second, but I know you don't entirely agree. Why is that?
Well, you're right. I think that is a phrase that you often hear in connection with proposals. There are no prizes for coming second, but I think it's a bit out of date. We're operating in an environment, as you well know, Sylvia, where panels are frequently used for the selection of law firms and the management of external legal spend. And it's not really anymore a binary outcome. I don't think it's a question of whether you just win or you lose. It's a more complicated picture than that. And there may be a whole series of different agendas that you as a law firm you can pursue without necessarily coming first. So I think it's too simplistic.
Can you give some examples of where coming in second actually has worked really well for a firm?
Yes, I think there are several categories. I mean, I mentioned panels. So it may well be that a law firm's real objective isn't necessarily to be top of the list, but to increase its kind of share of the spend. And to use a tender to put themselves in a stronger position without necessarily being the primary firm that company is using. I've also come across situations where, for example, smaller firms who are competing against much larger firms have been more than happy to be second or third on the basis that they don't want the lion's share of the work. They're very happy to get a share of the work which comes to them because they are the larger firms involved have conflicts, for example. So I think that they are examples of a situation where coming second can be entirely in line with what your strategy is. And another situation, which I think is important, is where you've maybe not had any previous history or connection with a company, but you do have during the course of the tender, where you have access to the decision makers. It's an opportunity to make a really strong impression. And that may mean that you don't win the work immediately, but at least you've created a platform from which you can build a relationship in the future. So I think there are all situations where not coming first can still be very beneficial. And I guess the message really is this, is that we need to take into account the precise objectives of a firm when they are assessing the sort of return on investment they want to get from entering into a tender situation.
Well, that is good to know. Thank you, John. This theme is explored in more detail in John's book, Winning Proposals, the Essential Guide for Law Firms and Legal Service Providers. It's published by the Buying Legal Council, and you can obtain copies from Amazon.com or Amazon.co, amazonco.uk. Thank you very much for listening to us.